Hey everyone, thank you for attending this very important webinar. I'm Nick Metz, retired Chief of Police from the Aurora Police Department, and now with Code-4 Counseling in Lone Tree, Colorado. Since the tragic death of Mr. George Floyd in Minneapolis, Minnesota, the division between the police and the community throughout our country is at an unprecedented level. There are talks about defunding, decertification, and lots of different types of reforms. Right here in Colorado, the state legislature introduced a bill that was recently signed by Governor Polis that outlined a number of reforms. The bill, Senate Bill 20-217, outlines issues having to do with qualified immunity, body-worn camera usage, and a whole host of other issues. Probably like you, I've been involved in a number of discussions where folks are very confused, they're scared and anxious about what these reforms mean and how it will impact them personally and how it will impact their families. One of the things I thought would be helpful would be to bring some experts on board, some experts who actually were part of some of the iterations of this bill over these last few weeks, and have them address with you what the bill is, and just as important, what the bill is not. So I contacted Mark Colin from Bruno, Colin law firm, as well as Steve Schultz from the state FOP. And they both jumped at the opportunity to be part of this webinar and hopefully answer many of the questions you have and hopefully lessen the confusion and anxiety that you and your family may share. Mark Colin and Dave Goddard from Bruno Colin law firm will start the webinar out, and then it will be followed up by Steve Schultz from the FOP. And then I will come back for some parting comments. I want to take this just quick opportunity to thank you for everything you are doing out there in the community and doing everything you can to still help keep our communities safe during this period. And I also want to thank the families who are part of this webinar. Thank you for sticking by your loved one, and thank you for supporting them and other law enforcement officers from throughout this state.
Hello, my name is Mark Colin, and with me on this presentation is my partner David Goddard. And we want to thank you for being provided this opportunity to address some concerns that have been expressed to us and hopefully to answer as many questions as we can associated with the Enhanced Law Enforcement Integrity Act legislation that was recently passed. Obviously, because this legislation is brand new and was written in a very short period of time, there are a lot of wrinkles to this legislation that have to be ironed out. And we expect that over the next several years, those wrinkles will be ironed out by courts of competent jurisdiction throughout the state, to include the Colorado Supreme Court. So for now, what we're trying to do is to address the most critical questions that have been raised with our office associated with how this legislation is going to impact law enforcement officers moving forward from the effective date of this legislation. Within these slides, you'll note that there are various effective dates noted at the bottom of the slides, and knowing when certain aspects of this legislation become effective is going to be an important part of evaluating what you and your agencies need to do in response. The areas of this legislation that seem to have given rise to the most significant concerns are civil liability, use of force, failure to intervene, and post-decertification. And those are going to be the four topic areas which we're going to focus on here during our presentation. Perhaps the most questions have been directed to language within 1321, 131, 2B of this legislation, which states qualified immunity is not a defense to liability pursuant to this section. The use of the phrase or the term qualified immunity, I think, is one of the reasons that concerns have arisen with regard to the potential effect that this legislation may have on a peace officer's entitlement to what has normally been viewed as a federal civil rights defense utilized in connection with claims brought under Title 42 of the United States Code, predominantly Section 1983, but certainly other subsections within that title of the United States Code. One of the major concerns that has been raised about this legislation is its impact on the defense of qualified immunity. You may have heard in news or read in social media the opinions of so-called experts that this bill eliminates the defense of qualified immunity to law enforcement officers. As we will discuss, this is not the case. The concern that I just articulated arises from the language in the new statute 13-21-131 paren 2 close paren B close paren, which states, quote, qualified immunity is not a defense to liability pursuant to this section, close quote. To understand the scope, application, and effect of this language, we first need to understand a bit about the history and operation of both the Colorado Governmental Immunity Act and the defense of qualified immunity. Colorado Revised Statute, Section 13-21-131, is the new section which speaks to a civil action for deprivation of civil rights. It essentially codifies a civil right of action against a law enforcement officer who is acting under color of law for a violation of rights secured by Article 2 of the Colorado Constitution. Article 2 of the Colorado Constitution is not newly created. Indeed, Article 2 of the Colorado Constitution, in many respects, mirrors the United States constitutional protection under the Bill of Rights. As a result, potential claims under Article 2 of the Colorado Constitution have existed for a very long time. Such claims, however, were not litigated in state court in Colorado because of some long-standing legislation called the Colorado Governmental Immunity Act. The Colorado Governmental Immunity Act addresses claims which lie in tort or which could lie in tort. Constitutional violations or deprivations of constitutional rights are essentially claims which lie in tort or could lie in tort. They are constitutional tort claims. As a result, the Colorado Governmental Immunity Act has for decades barred claims under the Colorado Constitution if such claims were claims that could or did lie in tort. As a result of the immunities provided to governmental entities and employees under the Colorado Governmental Immunity Act, which prevented the litigation of constitutional tort claims under state law, the majority of lawsuits asserting civil rights violations were brought and have been brought for decades in federal court under Title 42 United States Code, Section 1983, and the other provisions of the Civil Rights Act. As we will discuss in just a couple of minutes, the language in 13-21-131, which states that qualified immunity is not a defense to liability pursuant to this section, is a reference to claims brought under the Colorado Constitution, Article 2, and the legislatively created claim under 13-21-131. It does not apply to claims brought under federal law under Title 42 of the United States Code, Section 1981, 83, and 85. Thus, to the extent that there is a concern that this language, which indicates that qualified immunity is not a defense, is language that is limited to claims brought under the Colorado Constitution and this newly created legislative civil rights action under state law. It does not apply to claims brought in United States District Court under federal law. I want to touch upon a couple of other things that are addressed by this statute before moving on to a more in-depth discussion about qualified immunity and claims brought under Article 2 of the Colorado Constitution and this new legislation. It's notable that this new civil rights action for deprivation of rights also includes a civil rights action under Article 2 of the Colorado Constitution against a peace officer who, acting under color of law, fails to intervene to prevent a violation of a right secured by Article 2. We're going to be talking about the duty to intervene and this potential claim a little bit later. It's something also to note with regard to this new civil rights action is that there is a 2-year statute of limitations applied to claims brought under Article 2 for violation of civil rights, newly created statutory legislation 1321-131. It's notable that that statute of limitations is the same statute of limitations that is used in federal claims and applies to claims brought under Title 42 of the United States Code. Circling back for a minute to discuss the qualified immunity defense and its inapplicability in part to claims brought under this new civil rights statute under state law, we need to talk first about the history of the legislation, particularly as it relates to the Colorado Governmental Immunity Act, and why claims have not been previously asserted under Article 2 of the Colorado Constitution. The Colorado Governmental Immunity Act immunizes Colorado employees and governmental entities from any and all claims which lie in tort or could lie in tort, which include claims brought under the Colorado Constitution. As a result, historically, because of the prohibition in the Colorado Governmental Immunity Act from litigating claims which lie in tort or could lie in tort against governmental entities and employees, typically civil rights claims were brought in federal court. Civil rights claims arise under the Bill of Rights, specifically the Fourth Amendment and other amendments to the United States Constitution. Based on the federal preemption doctrine, you need to understand that state-created legislation cannot adversely impact either rights or immunities guaranteed by the United States Constitution. As a result, this language, which appears to diminish a police officer or law enforcement officer's entitlement to the defense of qualified immunity in a claim brought under federal law in federal court, does nothing of the sort. In fact, this qualified immunity limitation articulated in 1321-131-2B specifically says that qualified immunity is not a defense to liability pursuant to this section. And so this is a reference to the fact that while qualified immunity may be otherwise available and is still otherwise available in suits brought in United States District Court under federal law, the defense of qualified immunity as a whole, as applied in federal court, is inapplicable or unavailable to claims brought under Article 2 of the Colorado Constitution and under this new legislation. What does that really mean, however? Well, qualified immunity in the United States District Court, or as applied to claims asserted under federal law, 1321-131, also states that the Colorado Governmental Immunity Act does not apply to claims brought under Article 2 of the Colorado Constitution and this section, meaning 1321-131. Because governmental immunity doesn't apply to claims brought under Article 2 and Title 1321-131 of the new legislation. The governmental immunity that was previously available and could be asserted against claims which lie in tort or could lie in tort cannot be asserted as a defense to claims brought under this new legislation. The effect of the removal of governmental immunity as applicable to civil rights claims brought under Article 2 of the Colorado Constitution and this new legislation is to remove certain immunity protections and changes the playing field when it comes to attorney fee entitlements and other potential arguments that we used to be able to assert under the Colorado Governmental Immunity Act, as applied to these new civil rights claims brought under state law. It bears repeating, however, that this legislation does not eliminate or otherwise erode a law enforcement officer's entitlement to the federal qualified immunity doctrine when lawsuits are litigated in the United States District Court and claims associated with civil rights violations under the United States Constitution and the Bill of Rights are asserted in such litigation. Qualified immunity is a judicially created defense to federal claims. The Colorado General Assembly does not have the authority to overrule United States Supreme Court decisions. Only the United States Supreme Court and the United States Congress have the authority to do that. Colorado does not have an analogous qualified immunity doctrine to the doctrine that is utilized in claims asserted under Title 42 United States Code sections 1981, 83, and 85. Qualified immunity, as utilized in federal claims, has essentially two components. The two prongs of qualified immunity are either that there was not a constitutional violation in the first instance, or that the law associated with the alleged constitutional violation was not clearly established on the date of the incident complained of. Under our new civil rights legislation, the term most commonly associated with the assertion of qualified immunity on claims brought under the federal law relates to the use of the term objectively reasonable or objective reasonableness. That's the standard that federal courts apply to determine whether a constitutional violation was committed in the first instance. If a court were to find that there was a constitutional violation, the court must also find that the law associated with that constitutional violation was clearly established on the date of the incident. The new civil rights statute embodying civil rights claims asserted under Article 2 of the Colorado Constitution adopts the objective reasonableness standard as the standard to be applied when determining whether or not a constitutional violation of Article 2 of the Colorado Constitution occurred. Objective reasonableness, however, is not a term that is commonly utilized in Colorado statutes. It's also not a term that is commonly applied to claims brought under state law against law enforcement officers. Thus, right now, we don't have a lot of guidance as to how the phrase objectively reasonable or objective reasonableness is going to be interpreted as utilized in this new civil rights state-created legislation. Normally, when there is a absence of authority under state law, but there are common phrases between federal law and state law, we can turn to federal law to define terms like objective reasonableness and to argue that that same standard should be applied to claims brought under this new legislation and Article 2 of the Colorado Constitution. However, at this point, we don't know how we're going to fare in applying federal objective reasonableness doctrine to claims brought under Article 2 and this new legislation. What appears to be clear, however, is that while the objective reasonableness prong of qualified immunity has been reincorporated into this new legislation as a defense to claims brought under Article 2 and this new statute, it appears that the second prong of qualified immunity, that being proof that the law associated with the conduct at issue was clearly established at the time of the incident, has not been adopted by the legislature in this new civil rights statute. As a result, we don't know whether the second prong of an entitlement to qualified immunity under federal law is going to be applied to claims brought under this new state legislation. The effect of that is troubling. The whole idea behind requiring the law to have been clearly established as to the conduct at issue on the date of the incident is a requirement that law enforcement officers are entitled to notice that their conduct could be construed as violative of an individual's constitutional rights. That argument does not appear to have been disposed of by this new legislation, because arguably an officer is always entitled to know whether or not conduct violates somebody's constitutional rights. So we don't know what the effect of this removal of qualified immunity defense while adoption of the objective reasonableness standard is going to have on lawsuits brought under this new legislation. But it would appear that at a minimum, certain aspects of the qualified immunity doctrine that we have long utilized in defense of our clients in federal court for claims brought under federal law remain available to law enforcement officers who are now going to be sued under this new legislative doctrine. Claims brought under federal law to which qualified immunity still applies provide an immunity from suit, not just an immunity from judgment. It's unclear in this new legislation whether or not that same standard is going to be applied, meaning that you are entitled to assert objective reasonableness as a defense to a civil rights claim brought under this new legislation. And at what point are you entitled to a resolution of the question as to whether or not your conduct was objectively reasonable? Under federal law, you are entitled to a resolution of that issue as early as possible. And you are also entitled to bring what's called an interlocutory appeal should you disagree with a lower court's decision on the issue of an entitlement to qualified immunity. It is similarly unclear whether such an interlocutory appeal on the issue of the objective reasonableness of an officer's conduct would be available under this new legislation. When looking at 1321-131, a good faith belief that an officer's conduct was objectively reasonable remains a defense to a claim under this section. And similar to federal law and entitlement to the defense of objective reasonableness applies even if it is later determined that the officer was mistaken. So much like under federal law, a reasonable but mistaken belief that conduct was authorized by the Colorado Constitution appears to remain as a defense to a claim under this new civil rights legislation. All of that said, ultimately, then, what is the primary effect of this new civil rights legislation in Colorado on litigation of civil rights claims against law enforcement employees and their employer employing governmental entities now? What we believe is likely to occur is that we will now see more suits filed under this new Colorado civil rights statute and fewer claims brought in United States District Court or the federal court for violations of the Civil Rights Act embodied in Title 42 of the United States Code. Currently, when suits assert federal civil rights claims under Title 42 of the United States Code, it has been our practice to remove those claims to the United States District Court and litigate those claims in federal court instead of state court, because for the most part, state court judges haven't had to deal with issues associated with civil rights violations under the Colorado Constitution because of the Governmental Immunity Act and its prohibition, which has prevented in the past claims asserted of this nature from being litigated in state court. Now that that governmental immunity protection has been removed, we expect to see the civil rights claims, many civil rights claims that otherwise would have been filed in the United States District Court. Instead, we expect they will be filed in state court asserting violations of Article 2 of the Colorado Constitution. And the reasons for that are several-fold. The first of which we've talked about, which is the removal of the application of governmental immunity to claims brought under this section. So right out of the gate, plaintiffs' lawyers won't have to deal with the Governmental Immunity Act and its limitations and prohibitions against claims which lie in tort or could lie in tort. So it's opening a door to the assertion of such claims under state law in state court. One of the other reasons that it is likely that we will see more claims litigated under Article 2 of the Colorado Constitution and this new civil rights litigation law in state court is a change in the Governmental Immunity Act's entitlement to a mandatory attorney fee award to defendants who have been subjected to claims asserted which allege willful and wanton conduct in association with a punitive damage claim under state law. Now, the standard has been changed, and an attorney, a prevailing attorney, in a claim brought under Article 2 of the Colorado Constitution and this new state civil rights legislation, a prevailing plaintiff is entitled to an award of reasonable attorney fees and costs, and a court may award reasonable attorney fees and costs to a prevailing defendant for the defense of any claims the court finds are frivolous. That's a different standard than the previous standard available under the Colorado Governmental Immunity Act, which stated that a defendant who was sued for punitive damages and who was alleged to have engaged in willful and wanton conduct was entitled to a mandatory attorney fee award should the plaintiff fail to prevail on such claims. And so there is now a different standard that's going to be applied for an award of attorney fees under this new civil rights legislation that has been previously applied to claims asserted under state law against law enforcement officers and governmental employers. So you just need to be aware that the standard is now different for a plaintiff to recover attorney fees, although not significantly so. So a prevailing plaintiff under federal law in a civil rights case would have been entitled to attorney fees on any claim that they prevailed on. So the standard isn't much different for an award of attorney fees to a prevailing plaintiff, but the standard is different for an award of attorney fees to a prevailing defendant, and you should be aware of that. Probably most significant and of the greatest level of concern to our client organizations is the change in the indemnification obligations of a governmental employer when an employee is sued under this new civil rights state legislation. CRS 13-21-131 subsection 4 addresses the obligation of a governmental employer to indemnify an employee for any judgment or settlement entered against the officer for claims arising pursuant to this section. So, again, this new indemnification obligation only applies to claims brought under Article 2 of the Colorado Constitution and this new civil rights state legislation. It doesn't change the indemnifications of the Colorado available under the Colorado Governmental Immunity Act for any other kind of claim. So a car accident claim or something like that. So under this new indemnification provision, a peace officer's employer shall indemnify its officers for any liability incurred by the officer and for any judgment or settlement entered against the officer for claims arising pursuant to this section. Under the Colorado Governmental Immunity Act, the standard is a bit different. So here, for claims brought under the Colorado Civil Rights Statute, an employer must indemnify for any and all damages imposed against an employee for claims arising under this new civil rights statute, except if an employer determines that an officer did not act in quote-unquote good faith and with a reasonable belief that the action was lawful, the officer can be personally liable for 5% of the judgment or settlement or $25,000, whichever is less. This is actually a significant change in the employer's indemnification obligations to its employee, arguably to the benefit of the employee. Previously, an employer was not obligated to indemnify a governmental employee for a judgment if the employee's conduct was outside the course and scope of employment, or if the employee's conduct was willful and wanton. Similarly, there were limits that were placed on a governmental employer's indemnification obligation. The obligations or the potential exposure of an employer under the Governmental Immunity Act are capped for claims brought under Colorado law, except now claims brought under the civil rights statute. Those caps don't apply to claims brought under this new state civil rights statute. So the governmental immunity caps that previously limited a governmental entity's exposure to state law claims no longer apply to claims brought under this new Civil Rights Act legislation. However, while an employer could avoid an indemnity obligation entirely based on whether or not the employee's conduct was within course and scope of employment or willful and wanton, Now, no such ability of the employer to avoid indemnification applies to claims under this new legislation. So here, this new legislation obligates an employer to indemnify for any and all judgment or claims entered against an officer pursuant to this section. As a result, under this new civil rights statute, an employer is going to be obligated to indemnify its employee for any judgment or settlement, regardless of the amount. And if the employer alleges and determines in some yet unexplained process that the conduct of the employee was not entered into in good faith with a reasonable belief as to its lawfulness, then the employer nonetheless still has to indemnify the employee for any and all judgment or settlement except 5% of the judgment or settlement or $25,000, whichever is less. Thus, a reasonable reading of this new legislation would seem to say that a governmental entity employer is obligated to indemnify its employees for all judgments or settlements, except that the employee may have a maximum exposure of $25,000 for which he may be or she may be personally responsible if the employer determines that the conduct was not entered into in good faith. There was no such personal indemnification limit in the Governmental Immunity Act. So if an employee was determined to be willful and wanton or outside course and scope, they could be personally liable under the Governmental Immunity Act for the entire judgment or settlement. Not so under this new civil rights legislation. Under this new legislation, the maximum personal exposure of a governmental employee to a judgment is $25,000 or 5% of the total judgment, whichever is less. So, arguably, this improved a public employee's circumstance when sued in their individual capacity for alleged civil rights violations under Colorado law. The other exception to the employer's obligation to indemnify is if an officer is convicted of a criminal violation for the conduct from which the civil claim arises, then the employer is not required to indemnify at all. Once again, this is a substantial change from the obligations of an employer under the Colorado Governmental Immunity Act and the circumstances under which an employer may avoid its indemnification obligation when an employee is convicted of a criminal violation for the conduct from which the civil claim arises is less than clear at this point. For example, if an employee is charged criminally with, let's say, misdemeanor third-degree assault and takes a plea to something like a noise disturbance, is that the conduct from which the civil claim arose? Arguably not. And so we don't know what the effect of this statutory language is going to be ultimately. We can only identify some questions that arise as a result of the language that was adopted by the legislature as to this issue. And then ultimately the statute says if an individual officer is not able to pay that $25,000 or 5%, or the governmental entity is not required to indemnify because there is a criminal conviction, then in that event, if the officer can't pay that judgment, the governmental entity is nonetheless required to pay the judgment on the employee's behalf. So yet another modification to an employer's obligation to indemnify as it previously existed under the Colorado Governmental Immunity Act. As you can tell, this new legislation probably raises more questions than it answers, but I'm hopeful that at least with this summary with respect to qualified immunity, objective reasonableness, indemnification, attorney fee exposure, and those kinds of things, we've touched upon issues that have been of concern to you, and hopefully we have managed to at least reduce those concerns a bit as a result of this portion of the presentation. Turning now to the changes that were made by the legislature associated with use of force by law enforcement officers who are acting within the course and scope of their employment, I want to first touch upon the statute in general and then get into the weeds a little bit more with specific provisions and specific language that are going to affect the performance of your duties moving forward once this statute goes into effect. It's notable that this use of force language is not effective until September 1st of 2020, and that's in order to give law enforcement agencies and law enforcement officers an ability to train up, so to speak, on the new requirements under this legislation. So turning now to 18-1-703, use of physical force, special relationships. So in 18-1-703, under this new legislation, it clarifies the application of the use of physical force by an official in a jail, prison, or correctional institution is justified if it is objectively reasonable and the official reasonably believes it is necessary to maintain order and discipline. Once again, the legislature has taken a term that has been in common use in federal civil rights claims, that term being objectively reasonable, and has now incorporated that term into state legislation associated with application of force by law enforcement employees. As we mentioned earlier, there isn't a lot of law here in Colorado which defines the term objectively reasonable or objective reasonableness. And thus it's our expectation that many state courts will turn to federal law in order to get a good, solid definition and understanding of what the term objective reasonableness means. Objective reasonableness, when applied to uses of force, essentially has been characterized in federal court as the no reasonable officer rule. So whether it's a use of force, a determination of probable cause, an arrest situation, whatever that might be, in federal court, the short version of objective reasonableness is that no reasonable officer would have believed that probable cause existed, or reasonable suspicion existed, or exigent circumstances existed. Or in the case of force, no reasonable officer would have believed that the application of force was reasonable and necessary. So that's how federal courts have interpreted objective reasonableness when applied to force claims brought under Title 42 United States Code, Section 1983. Here, the legislature has taken the term objectively reasonable and applied it to the conduct of jail officials, prison officials, or those employed by correctional institutions. So, if the definition that has been developed in the federal jurisprudence is applied to this term as it is used in this statute, then your conduct would be objectively reasonable so long as a reasonable officer in your circumstance would have believed that the force that was applied was necessary to accomplish the goal. Here, the goal being the maintenance of order and discipline. Again, the statute applying it to jail, prison, or correctional employees adopts the term objectively reasonable when it states that deadly force may be used by an official in a jail, prison, or correctional institution when he or she objectively reasonably believes the inmate poses an immediate threat to the person using deadly force or another person. Well, that's similar to, but not exactly like, the standard that has been applied for years in Colorado, which is that you need to believe that there is an imminent threat of death or serious bodily injury in order to justify the use of deadly force. So this seems to be a blend of the federal term objective reasonableness to a state-created standard of immediate or imminent threat. It does not, however, adopt the state language which says imminent threat of death or serious bodily injury to another person. So the question still remains as to whether or not that language from our state statute is really going to be applied to an analysis of a use of physical force under this portion of the use of force statute. Turning now to 18-1-703, subparagraph 2. When physical force is used, an officer shall A, not use deadly force to apprehend a person who is suspected of only a minor or non-violent offense. No legal definition of minor or non-violent offense is provided. So right now, law enforcement employees and their lawyers are being forced to speculate as to what this language really means. And then, of course, as you all know, what starts out as a contact for a minor or non-violent infraction oftentimes escalates into a much more significant criminal infraction involving violence. Under those circumstances, is this standard applied or not? Does it matter whether or not the initial contact was only for a minor violation, so long as it escalates to a point where deadly force or other physical force is reasonable and appropriate? So that's a question that is raised by this statute for which we don't have an answer. Even more problematic is the language that appears in subsection B, as in boy, of subparagraph 2. When physical force is used, an officer shall, use only a degree of force consistent with the minimization of injury to others. I think it's fair to say that all of the attorneys in my office wrote a margin note next to this language that says, what the heck does that mean? We don't know what it means. Only a degree of force consistent with the minimization of injury to others. So are the others referenced here others other than the suspect against whom the physical force is being applied? Probably not, but arguably that's what the statute says. So if we are applying it to the suspects, use only a degree of force consistent with the minimization of injury to the suspect. If that's what the statute means, what kind of force does that apply to? Does this change the toolbox approach that has been applied to use of force in law enforcement circumstances for the last decade or so? Other language in this statute, which I'll mention in a moment, seems to revert back to the old pyramid or ladder of force and seems to discourage the toolbox approach which has been adopted for many years. Certainly, it's unclear at this point what the effect of this new language is going to be. And then it's interesting to note that this applies an obligation to an officer. So 18-1-703 subparagraph 2 says when physical force is used, an officer shall. But subsection D seems to be what would otherwise be an obligation of an employer. An officer shall ensure that any identified relatives or next of kin of persons who have sustained serious bodily injury or death are notified as soon as practicable. Well, that's usually some sort of a victim protection person's obligation or an agency's obligation, not an officer's obligation. I suspect that this language is going to be addressed in law enforcement agency policies, which otherwise assume this obligation for the agency and not the officer. But under the statute, if there is a failure of the agency to notify or of a victim representative to notify, it is the officer, not the entity or the victim's representative, who will be potentially liable under this statute. And then the question arises, what liability are we talking about here? Is it civil liability or is it some form of criminal liability if there's a failure to notify? So these are all questions that I think need to be addressed with your employer, and policies adopted to resolve some of the questions that have been created by this legislation. I mentioned a minute ago that 18-1-703, use of physical force by peace officers, defines the use of force. This provision, as with the others associated with the use of force, becomes effective September 1, 2020, and hopefully between now and then we might get some more guidance as to what some of this language means. But 18-1-703, under the definition of physical force, requires officers to apply nonviolent means, comma, when possible, comma, before resorting to the use of physical force. This is the language that I was mentioning a moment ago when I questioned whether or not this language in the definition of use of physical force is going to revert law enforcement trainers back to a pyramid or ladder of force instead of the toolbox approach that has been applied for the last decade or so. Again, this statutory language raises that question but doesn't resolve that question. So, as we know, when you're using the toolbox approach, you pull the tool from the box most appropriate to deal with the situation with which you are being confronted. Here, it appears that at least before using force, you have to consider using nonviolent means. I think arguably what this really means is that officers are going to have to do a better job, a more thorough job, of articulating in their reports or any verbal statements why any lesser means of force would not have been effective to confront a suspect. So hopefully we are not reverting back to an old use of force ladder or pyramid, but what the statute effectively may be doing is requiring officers to consider before using force whether or not any means of de-escalation are appropriate and available, and to use those means if they are appropriate and available. Otherwise, if you pull from the toolbox and use a degree of physical force in order to address whatever you're confronted with, you need to articulate why a lesser means of force would not have been effective or appropriate. That's a little bit different than the application of the standard used in federal civil rights cases, which doesn't allow Monday morning quarterbacking or other less forceful means to be considered by a jury when evaluating an officer's use of force. The jury in a federal case is to consider only whether or not the force that was used by an officer at the time was objectively reasonable, not whether other lesser or alternative forms of force may have been appropriately deployed. So this statute raises questions in the definition as to whether that standard, which has been applied to law enforcement officers' uses of force in federal court, is going to be the same standard applied under this state statute. Other language within this new use of force legislation of note is that peace officers are now prohibited from using a chokehold upon another person. Chokehold versus a carotid hold are two entirely different things, and one must question whether or not this chokehold prohibition applies to carotids. We believe it does. We believe that that was the legislature's intent, but the language is less than clear. 18-1703, subsection 3. A peace officer is justified in using deadly physical force to make an arrest only when all other means of apprehension are unreasonable given the circumstances, and the arrest is for a felony involving conduct including the use or threatened use of deadly force, or maybe suspect poses an immediate threat to the officer or another person, or the force employed does not create a substantial risk of injury to other persons. This part of the use of force statute is effective now. It became effective upon the governor's signature on June 19, 2020. Thus, there is no training period or allowance period until September for officers to get trained up on what this new language really means. If you read it carefully, I don't know that this new statute applies much of a different standard, but it's a different standard. So previously, you could use deadly force if confronted with a situation which could reasonably be believed would result in imminent death or serious bodily injury to you or to another person. This language is a little different, but similar. So when you get to these subsections, you are entitled to use deadly force only when all other means of apprehension are unreasonable. So arguably that means if you're confronted with an imminent threat of death or serious bodily injury. And this is a distinction that's important. The arrest is for a felony involving conduct including the use or threatened use of physical force. Well, to a certain degree, that implicates the fleeing felon statute. Previously, you couldn't simply shoot a fleeing felon. We know that from Tennessee versus Garner. But an officer could use deadly force to apprehend a fleeing felon if the fleeing felon was using a deadly weapon or threatening to use a deadly weapon to aid in escape, or was fleeing from a crime involving the use or threatened use of a deadly weapon. Query whether or not this new language changes that fleeing felon defense. So currently, if the arrest is for a felony involving conduct including the use or threatened use of deadly physical force, you can use deadly force. It's, again, a little bit different than the statutory language under the fleeing felon rule. So I suspect that your agencies are going to be developing new training protocols and new policies to provide better guidance on what your agency's expectations are when you have utilized deadly force or you need to utilize deadly force under these circumstances. Currently, I think we are still safe in relying on an imminent threat of death or serious bodily injury to yourself or to another to justify a use of deadly force. I think that standard is subsumed within this new statutory framework. So, next part of this statute, and this portion of the statute doesn't become effective until September 1, 2020, 18-1703, subsection 4, a peace officer shall identify himself or herself as a peace officer, give a clear verbal warning of his or her intent to use a firearm or other deadly physical force, and allow sufficient time for the warning to be observed. So all of that's a little bit different, except the next provision sort of readopts the previous standard, unless to do so would unduly place the officer at risk of injury or create a risk of death or injury to other persons. So that was previously the standard. If you had a situation where it was impractical and unreasonable to announce before utilizing deadly force, you were protected. And it seems like that protection is now embodied in this last provision that I just read to you. Unless to do so would unduly place the officer at risk of injury or create a risk of death or injury to other persons. So essentially what this statute does is add some potential obligations on the part of a police officer to identify and announce, but those obligations only apply if you have an opportunity to do so without placing yourself or another party at risk. So it seems like the legislature taketh away and then giveth back when it comes to this section of the legislation. 18-1703, subparagraph 4.5. Again, we are now adopting a federal term of art, objective reasonableness, and applying it to uses of force under Colorado law. A peace officer is justified in using deadly physical force if the officer has an objectively reasonable belief that a lesser degree of force is inadequate, and the officer has objectively reasonable grounds to believe and does believe that he or another person is in imminent danger of being killed or receiving serious bodily injury. So again, we've taken that previously utilized standard of imminent death or serious bodily injury and readopted it into the objective reasonableness standard and added an objectively reasonable belief that a lesser degree of force is inadequate. So, I think the analysis in a deadly force situation is the same as it has always been, and that assuming that you have reasonable grounds to believe that you or someone else is at imminent risk of death or serious bodily injury, in my view, that automatically infers that a lesser degree of force is inadequate. I'm worried here under this new legislation that 2020 hindsight and Monday morning quarterbacking, which are expressly prohibited when analyzing qualified immunity and objective reasonableness under federal law, whether or not those standards are going to be applied to uses of force when evaluated under this new statute. One last point to make on uses of force. And this has to do with law enforcement responses to protests. And this new provision is found at 24-31-905. And essentially, what this statute does is prohibit law enforcement from using certain kinds of less lethal tools that had previously been available to them to address protests. What's unclear here is there is no distinction made between violent protests and peaceful protests, and unfortunately, that seems to have been the primary motivation behind the adoption of this legislation, which was the alleged use of less than lethal projectiles or other kinds of things like chemical agents, irritants, pepper spray, that kind of thing, against nonviolent protesters. So what I can tell you is that under this new statutory prohibition, it is prohibited for law enforcement to utilize kinetic impact projectiles or other less lethal projectiles to target the head, pelvis, or back of an individual. It's illegal or prohibited for law enforcement to fire such kinetic impact projectiles into a crowd, quote unquote, indiscriminately, or to use chemical agents or irritants without first issuing an order to disperse and giving the crowd an opportunity to disperse before deployment of such chemical agents. So essentially, it's a mandatory compliance period. You have to give the order, give an opportunity to comply before you use chemical agents. Thou shalt not indiscriminately fire less lethal projectiles or kinetic impact projectiles into crowds. And as your training protocols probably required already, you aren't to target the head, pelvis, or backs of individuals when firing these kinetic projectiles. Clearly, law enforcement training has prohibited firing these kinetic projectiles at a protester's head. Query whether or not the pelvis and back have always been included in your training protocols, but that may be a change you should become aware of and should be addressed in department training protocols and policies. I'm going to turn this over to my partner, David Goddard.
Thanks, Mark. All right, let's turn our attention to the duty to intervene. Senate Bill 2217 amended the use of force reporting statute to actually create a duty to intervene where one arguably wasn't before. Along with that duty to intervene, also created a duty to report that intervention, which was similar to the use of force reporting provisions that you're already used to and were already part of the Colorado Revised Statute. So, amending CRS 18.8.802 1.5, which was the duty to report use of force, this is where they've inserted the duty to intervene and the duty to report intervention. This was effective upon the governor's signature, so it is law now. It went into effect on June 19th when he signed the bill. And what that new duty states in the statute is an officer shall intervene to prevent or stop another officer from using physical force that exceeds the degree of force permitted by the statute. So this presumes a couple of things. First, it presumes that an officer has an opportunity to observe what another officer is doing, and then that officer has to conclude that whatever that officer is doing is excessive. If those two things exist, then there is a duty to intervene to prevent that excessive use of force, whether it's in making an arrest, placing a person under detention, taking a person into custody, or anything through the booking process, or in the process of crowd or riot control without regard to the chain of command. So in any of those instances, if Officer B observes Officer A doing something that is excessive, in those situations, there is now a duty under the state law for Officer B to intervene. In addition to the duty to intervene, there's also a duty to report that intervention to an immediate supervisor. And the terms under that reporting are very similar to the terms that exist or currently exist under the reporting of the use of force. That is that the report must be in writing, it must be made within 10 days of the use of force incident, and the report reporting the intervention must be attached or appended to all other reports on the incident. That's very similar to the requirements that are currently that were in place prior to June 19th for the reporting of the use of force. They've now just applied those same reporting requirements and mechanisms to reporting the duty to intervene or the intervention from Officer B in the conduct of Officer A. It also provides some protection to an officer who does intervene and who does report said intervention. And the state statute specifically indicates that no officer shall be disciplined or retaliated against. So that means retaliated against by the department, discipline, or retaliated against by other members of the force or fellow law enforcement officers, that no officer shall be retaliated or disciplined for intervening, for reporting unconstitutional conduct, or, and this is of great significance, failing to follow what the officer reasonably believes is an unconstitutional order. So not only is there a duty to intervene to prevent excessive force, there's a duty to report that, but if you feel like you're being ordered by a superior to engage in excessive force, you have the obligation, if you reasonably believe that that is an unconstitutional order, not to follow it. And this legislation provides an officer cover or protection if they engage in that or do that. What you have to be clear, though, is that your belief that it is an unconstitutional order must be a reasonable one. It's also unclear, based upon the duty to intervene, is what is the nature of the intervention that is to be expected. In other words, is an officer simply expected to attempt to prevent or to intervene to prevent the application or the use of excessive force? Or is that officer expected to actually be successful in preventing the application of excessive force? Again, these are unclear. It's a new statute. There is no case law interpreting it, and we suspect that that will be the subject of litigation moving forward. I think to reasonably read the statute, an officer is obligated to intervene to attempt to prevent the excessive application of force. Whether or not they're actually successful in doing that, I don't think an officer can be held liable if there's a reasonable attempt. But that gets us to liability, and so there's two types of liability that are imposed by this statute. The first is a civil liability for an officer to fail to intervene, and this goes back to the state civil right of action that Mark was talking about that's contained in this bill. So it's a new state claim, and just like what Mark was speaking about with respect to claims that were brought under Article 2 of the Colorado Constitution, because the duty to intervene is new, there will be no state law or very little state law interpreting what that means. And so therefore, in the absence of state law, courts are going to look to federal law or analogous federal law to decide what the elements are or what the standards are for an officer who is required to intervene or expected to intervene. So looking and turning to the federal law, the current elements for a Fourth Amendment failure to intervene, which would be analogous to the new state duty, are as follows. And again, I'll use the Officer A and Officer B example. So Officer A, first of all, a plaintiff would have to prove that Officer A actually committed a constitutional violation against a plaintiff. So in a force situation, which is the easiest example, there would actually have to be an establishment that there was an unconstitutional use of force or excessive force applied to a plaintiff. And then Officer B would have had to have been in a position to observe that force, or would have had to possess knowledge that Officer A was about to commit a constitutional violation against the plaintiff. So in order to sustain a civil claim, you have to have a use of an unconstitutional or a constitutional violation, so an unconstitutional use of force, and you had to have an opportunity to observe it or have knowledge if you're the second officer who is expected to intervene in the situation. You would have had to have been in a position to observe or had the knowledge that the other officer was either using unconstitutional force or creating a constitutional violation, either observed that or knew that they were going to do it. And further, Officer B has to have a realistic opportunity to actually intervene and prevent the harm. So think of this example of a single punch or a single kick. Officer A may apply excessive force through a punch or a kick, that could be considered a constitutional violation against a plaintiff, and Officer B could have observed that punch or kick. But if it's a single punch or kick, then arguably Officer B has not had a realistic opportunity to actually intervene and prevent that harm. In that type of situation, we do not believe that there would be liability for Officer B under this statute. But again, this hasn't been tested in state courts. The final element of the federal law for liability on duty to intervene is that Officer B then, after having a realistic opportunity, failed to take advantage of that opportunity and failed to attempt or take reasonable steps to prevent the harm, and the plaintiff actually suffered harm. So again, if we're looking to analogous federal law, there has to be a constitutional violation by Officer A. Officer B has to be in a position to either observe that violation or know that that violation is going to occur. Officer B has to have a realistic opportunity to intervene and prevent that harm, and then Officer B has to let that opportunity pass without attempting to prevent the harm. If those four elements are met, then there is liability under federal law. We expect that under the new state law claim, that again, state courts are going to turn to the federal law, at least initially, until they establish state law or state analysis of this statute. In addition to civil liability, this statute also creates a new criminal offense. The statute states that an officer who fails to intervene to prevent the use of unlawful force commits a Class 1 misdemeanor. Now again, it's important to look at the language. The language appears to be limiting here. And it says an officer who fails to intervene to prevent the use of unlawful physical force. So under the new criminal statute, it does not appear to create a criminal offense for an officer who does not intervene on some other constitutional violation, such as maybe a false arrest or an unlawful seizure. The language of the statute specifically here states that it is an officer who fails to intervene to prevent a use of unlawful force commits a Class 1 misdemeanor. Now, it is unknown whether or not the legislature meant to or intended to apply the duty to intervene to all constitutional violations, but arguably the language here limits it to an application of force situation. In addition, a finding by an administrative law judge or an internal investigation that an officer failed to intervene to prevent the use of unlawful force must be presented to the district attorney for consideration of filing criminal charges. So, if you have a force situation and a force review that is conducted by your employer, and there is a finding in an internal affairs investigation, and or there is, as a result of that, there is discipline imposed, which is somehow appealed, through a career service or civil service or some other administrative review process, and an administrative law judge finds that an officer failed to intervene. So either you have a finding by the internal affairs or you have a finding by a hearing officer or an administrative law judge that an officer failed to intervene. The department, in addition to taking administrative action against that officer, now has an obligation and a duty to present that information to the district attorney for the district attorney to consider whether or not to file criminal charges for the failure to intervene. In certain situations where the district attorney's office would have charged Officer A for the use of excessive force, but declines charges against Officer B, who was on scene and failed to intervene in such force, if the DA decides to charge the officer who used the force, but elects not to charge an officer who did not intervene, the DA is now required to prepare and publish a report explaining the reasoning and the basis for that decision. So again, the statute is attempting to address here prosecutorial discretion, and if a district attorney exercises that discretion and elects not to file charges against an officer for failure to intervene, and they've charged another officer for excessive force, the law now imposes an obligation on that DA to publish the reasons for that decision and answer publicly for that decision. Finally, the statute also allows for officers who fail to intervene to be charged under other criminal theories of criminal law. So an officer, in addition to being charged with failure to intervene, could also be charged with conspiracy or accessory crimes under legal theory. So, for example, in a use of force situation, if Officer A is charged with assault, Officer B fails to intervene, in addition to being charged with the Class 1 misdemeanor of failure to intervene, they could also be charged with conspiracy to commit assault or accessory after the fact to third-degree assault. Of course, the statute also does not address, and one of the open questions that we have with respect to filing of criminal charges for an officer, against an officer who fails to intervene, if it is the result of an administrative investigation or internal affairs investigation, oftentimes, and it is our advice to clients when they go into those interviews to request and seek a Garrity advisement. So it's an open question as to if through the process of an internal affairs investigation, the employer decides that an officer should have intervened but failed to do so, and now they're required to turn that information over to the district attorney's office, there's an open question as to whether or not the district attorney can even rely upon that information under Garrity. Because just as a quick refresher, Garrity versus New Jersey, that's a Supreme Court decision, a United States Supreme Court decision, and what that case stands for, the proposition it stands for, is that based on the employee and employer relationship, even though individuals have a Fifth Amendment right not to self-incriminate and not to provide statements against one's self-interest, an employer can compel an employee to do just that. And when they do so, those statements that are in fact compelled cannot be used against the employee in any criminal prosecution. So this statute seems to require that an agency, once it makes the determination in an internal affairs investigation that an officer should have intervened but failed to do so, that agency has to turn over that information and that decision to a district attorney who, if you apply Garrity and there was a Garrity warning provided, cannot take action upon that information because it would be compelled and would be against that officer's Fifth Amendment right. And so what we anticipate may happen is you may very well see in those situations a letter from the district attorney's office saying, well, we would have prosecuted, but the evidence to prosecute is unavailable to us because it is protected under Garrity and was obtained in a compelled manner, and we can't use compelled statements to prosecute officers. But again, this is a new statute and relatively untested, and so we believe that will be the subject of future litigation should this situation arise. Finally, with respect to the duty of intervention or the duty to intervene, the statute requires employers to do several things once they make that determination. The statute requires that by a finding of an administrative law judge, a hearing officer, or an internal affairs investigation, that an officer failed to intervene and the incident resulted in serious bodily injury or death, in that situation, an employer shall discipline the officer up to and including termination, and the post board shall permanently decertify the officer upon notice of the discipline from the employing agency, and that post revocation may only be overturned if the officer is exonerated by a court. So what does that mean? Well, we find that discipline here is mandatory, although the level of discipline appears to be discretionary with respect to the employer. because it says the employer shall discipline an officer up to and including termination. So certainly the agency could decide to discipline the officer in some fashion short of termination. However, that discretion may be of little consequence because of the next provision, which is upon notice of that discipline, whatever that discipline may be, the post board is obligated to permanently decertify an officer upon receipt of that notice. So even if the employing agency impose some discipline short of termination, a suspension or a demotion, the result of that discipline, according to the new statute, will result in a permanent decertification of that officer. And so once that officer is now no longer post-certified, that's effectively a termination of their employment for any law enforcement position that requires post-certification. So, although on its face it appears to give employers some discretion, again, this is a situation where the legislature giveth and then the legislature immediately taketh away, because with respect to the post-decertification, that is mandatory and it is permanent under those circumstances. Unless, of course, the revocation is overturned by the officer being exonerated by a court. And here what that likely means, because this is an administrative proceeding, is that under Colorado law, there is a administrative review provision. It's commonly referred to as a 106 hearing. So once you have a final decision or a final administrative decision from an employer, that decision, which is considered to be quasi-judicial under the law, can be reviewed by the district court in the jurisdiction in which the agency resides. And so an officer could appeal, once that officer had exhausted all of his or her administrative appeals within their jurisdiction or their municipality or within their sheriff's office, they could file suit in the district court for a 106 review. Of course, the standards for a 106 review are pretty tough to meet and pretty tough to overcome, because a 106 hearing to review the quasi-judicial decision of an ALJ or a hearing officer or an agency action, the purpose of the 106 hearing is to determine whether or not the agency acted in an arbitrary or capricious manner. So whether or not they acted arbitrarily and capriciously with respect to the decision. Now the burden at a 106 is on the officer, and that burden is a very high burden, because there is a presumption that the agency actions were proper and were thus not arbitrary and capricious under the law. So not only does the officer bear the burden to show that the agency acted in an arbitrary and capricious manner, but unfortunately under the law there's a presumption that the agency acted properly. And so success at a 106 hearing is very rare. But this statute provides the provision that if an officer were to somehow be exonerated by a court and prevail at a 106 hearing, that permanent revocation of their post-certification could be overturned. Finally, Senate Bill 2217 enacts a new statute or a new portion of the statute that deals with post-certification, and this is found at 2431-904. And the statute requires that the post board shall permanently revoke a peace officer's certification if any of the following occur. An officer is convicted or enters a guilty plea or a no contest plea to a crime involving unlawful use or threatened use of physical force, or if an officer is convicted or enters a guilty plea or a no contest plea to a crime involving failure to intervene in the use of unlawful physical force, or if an officer is found civilly liable for the use of unlawful physical force, or if an officer is found civilly liable for failure to intervene in the use of unlawful physical force. And post board shall not reinstate unless the officer is exonerated by a court. So if an officer is convicted pleads guilty or no contest to the unlawful use of physical force or failure to intervene in the use of unlawful physical force, the post board is required to permanently decertify that officer. Likewise, if an officer is found liable in a civil court, whether that be state or federal, for the use of unlawful physical force or the failure to intervene in that unlawful use of physical force, likewise, the post board is required to permanently decertify that officer. Now, again, there's still the provision in there that the post board shall not reinstate or overturn the revocation unless the officer is exonerated by a court. Here we're not dealing with a 106 standard, but here we would be dealing with, in a criminal context, any appeal of any criminal conviction. So if an officer goes to trial, is convicted, that officer can appeal that conviction. If that conviction is overturned by an appellate court, then the post decertification or the revocation of the post certification likewise would be overturned. The same would be true for a finding of liability under in a civil court or a civil setting. Again, once an officer filed an appeal of that finding of liability, if that was overturned or reversed by a court, so too would the post decertification or revocation. And again, this post decertification statute went into effect on June 19th, 2020 upon the governor's signature. So as we've discussed, this legislation provides more questions than it really provides answers. And we believe many of these questions will be subject to litigation and court interpretation moving forward and in the future. But what we've provided you today are really our early first impressions of the impact of this legislation and this bill on law enforcement officers and their work. We hope that you find this information valuable and that we were able to answer some of the more pressing questions that you have about this legislation. Thank you for your time and attention, and stay safe out there.
My name is Stephen Schultz, and I am the president of the Colorado State Lodge. The Colorado State Lodge welcomes you to this presentation, and we hope at its conclusion you will have a clearer understanding of the impacts of Senate Bill 217 and what was done by the Colorado State FOP and other police organizations to minimize the potentially devastating impacts of the original bill. The unfortunate events in Minneapolis started a snowball effect and a minefield at the state capitol, which we've traversed through with significant strides. We started out behind the eight ball on the introduction of this bill, as neither us nor any other law enforcement organizations were involved on the front end in the crafting of the language in the original bill. Due to our proactive outreach efforts, we were able to review a draft of the bill and begin speaking with bill sponsors and legislative leadership prior to its introduction, but not until the day before it was officially introduced. Through our lobbyist and state lodge leadership, the FOP took a leading role in crafting amendments and working with legislators on both sides of the political aisle to get this bill to its final form. There were more changes we wished to see, and we worked hard to try to incorporate into this bill to protect our members, our profession, and the communities we serve. Though we were unable to obtain some of the asks we made, we are committed to continuing our work on this and other policies that we anticipate being brought forward during the 2021 legislative session. One party, the Democrats, currently control the Colorado House, Senate, and Governor's office. Every single Democratic legislator signed on to this bill as a co-sponsor prior to the bill being introduced. This meant that they had the votes to pass the bill as it was initially introduced, but we were able to work on significant amendments nonetheless thanks to the work of our lobbyist, our public relations specialist, our members, and the input from state lodge leadership. As you will see from the next 3 slides, this bill moved extremely quickly through the legislative process. We will not go through each of these slides in detail, but the speed with which this bill moved and the scope of the content it covered is unprecedented. During the course of the brief 11 days that the bill was actively moving through the legislature, 43 amendments were added to the bill and over 140 were drafted for potential consideration. We highly recommend that officers read the entire text of the final version of the bill, which is linked within the matrix summary on the FOP's website. FOP worked tirelessly on improving this bill as it moved forward with the tremendous effort showing the strength and voice of the FOP through our legislative advocacy, direct member outreach to the legislators, and media interviews and statements. Understandably, we've gotten a lot of questions from members about how it and when this legislation will impact them. Through the majority of the sections of this bill went into effect immediately when Governor Polis signed the bill on June 19th, 2020, several sections were delayed. We've heard a lot of concerns about the impacts of the section of the bill related to body-worn cameras. This section will not go into effect until July 2023 and will likely need some cleanup before then, as many questions related to the privacy, safety, and cost arose during legislative discussions about this section. The statewide searchable database related primarily to use of force incidents will also not go into effect until 2023. The majority of the changes related to the use of force standard do not go into effect until September 1st, 2020. Effective immediately, however, chokeholds are banned and the fleeing felon standard has changed. Additionally, the creation and implementation of a statewide database related to untruthfulness, terminations for cause, and decertification was delayed until January 2022. The FOP intends to continue advocating for the creation of a fair and consistent process for adding an officer's name to the database. We are already engaging in follow-up conversation with legislators and key organizations about this and future legislation. We are also exploring insurance coverage options for ensuring officers have access to insurance policies. We are hoping to have a solid answer to this within the next week. FOP members should visit and log into our website to review the entire matrix outlining how the bill changed throughout the entire process. I can't stress enough how important it is for local lodge leadership and members in general to have a relationship with their local and state legislators. This needs to be an ongoing relationship and not one that only arises in times of need. It's too late if this is when we are engaging them. The State Lodge is happy to help coordinate these conversations. Rest assured, our work is not finished. This legislation as amended does not mark the end. In fact, it marks just the beginning of what will be ongoing efforts, both politically and professionally, to identify and address areas of continued concern for our members and the communities we serve, and to advocate for well thought out police reform in our state. As your representative organization, that is our commitment to you and our profession.
On behalf of Code-4 Counseling, the law firm of Bruno, Colin, and Lowe, and the Colorado State Lodge of Fraternal Order of Police, we want to thank you for tuning into this very important webinar. We hope that the information answered many questions that you had. We hope that it maybe settled a little bit of anxiety for you. If you have questions in the future, feel free to reach out to any of the three organizations, and hopefully we can answer whatever questions that you may have. We know that this is a very difficult time in our country right now, and in particular for law enforcement. And I just want to take a quick moment to remind you of your three priorities. 1, take good care of yourself. 2, take care of your family. And 3, take care of your peers. But you have to take care of yourself to really take good care of your family and peers. Your job is to go home at the end of shift physically healthy and emotionally healthy. And we appreciate everything that you do every single day to continue to keep our community safe, despite all the difficulty that is going on around our communities. You know, in the last few weeks, I've taken a lot of phone calls from folks who are questioning whether or not they want to stay in the profession. And I completely understand why they may question that right now. And I'm sure for some right now, it feels kind of an us versus them as it pertains to their relationship with the community. Things are really heavy right now, but I really truly believe that things will start to level out in time. And I think we'll be able to realize that some of the reforms that are being put in place may not be quite as daunting as we initially thought. But if you are questioning whether or not you want to stay in the profession, I ask that you do a few things. One is, don't make the decision to leave this profession while your temperature is high. Cool down a little bit. And that may take a few days, it may take a few weeks, but take some time to let the temperatures cool so that you can see and think clearly about what it is and why it is you may want to move forward on leaving this profession. And really think it through. And make sure you do have a plan. And that's going to be really important. But I also ask that you remind yourself why you got into this profession. And I know for many of you, you had a very idealistic view of being there to help people and making a difference in the community. And it may be really difficult to see right now, but I guarantee you that if you really look closely, whether it's in the past or even things that may come up with different types of incidents or events that you respond to, something will make it very clear to you that of why you chose this profession, of why you chose this calling. And you need to know that you make a positive difference every day. And maybe sometimes when you go home at the end of shift, you wonder, what good are you doing out there? But again, this is one of those areas where you really need to look closely. And I guarantee you that you are making those positive changes and those positive differences every single day. But at the same time, if you end up deciding that it's best for you to take a different path, I totally get it and I totally respect that. And always know that your blue family supports you. And know that if you need something from your blue family, they'll be there for you. And if down the road you choose to come back, your blue family will embrace you with open arms. I want to take a moment to send a message to law enforcement leadership. And when I talk about law enforcement leadership, I'm talking the first line supervisor through the chief and sheriff. Your leadership right now is absolutely critical during this very tumultuous period. People are looking to you for answers. They're looking to you for stability. They're looking to you to see if you have their backs. And one of the things I'm hearing often from folks around the state is that there seems to be this radio silence from department leadership. And the radio silence, it's not necessarily intentional. It's certainly not to be mean-spirited or anything like that. But I think for a lot of folks right now, they don't have the answers and they don't know what to say. So for some, they don't say anything. And I think we have to remember that lack of communication creates suspense, and suspense creates stress. So even if you don't have the answers, even if you can't share something because of its confidentiality, it's okay to at least explain that so that people know that you are cognizant of the fact that they are looking for information. And that at least if you don't have the answers right now, you are trying to get those answers and you will let them know as soon as you can. It's also going to really be important to be as visible as you can to your folks, whether it's visiting roll calls, riding with patrol, management by walking around. But be out there. Give folks an opportunity to have one-on-one conversations with you in the hallway or out in the parking lot. And give people an opportunity to speak frankly to you. If they disagree with a decision or a direction that the department is going, give them permission to be able to express that to you. It does a few things. Number one, it creates mutual respect, especially when that critique is done in a respectful manner. And it builds trust. It builds trust between leadership and officers and other employees. But let's not also forget the families. The families of our officers out there are really going through a great deal of confusion and a great deal of angst in everything that is going on. And they are questioning whether or not they want their loved ones to continue in this profession, whether it's because they're concerned for their safety, if they're concerned for the liability issues that may present themselves. This is why it becomes incredibly important to be visible with the family. So having things like family nights and date nights, doing virtual Zoom meetings with the family members, and letting them and keeping them as informed as you can about what is happening, what the latest reform issues are, what the latest policies issues are. Keeping them in the loop means a great deal to them, And just like with your employees, give them the freedom and opportunity to push back, respectfully, of course, on things that they may disagree with. And again, it will create a great deal of trust when you can have that respectful mutual dialogue. And they'll know that you have their loved ones back. You have my contact information here on the screen. If there's ever anything I can do to assist you or your families or your organization, please do not hesitate to reach out. We love you. We care greatly for you. We want you to be safe. And thank you for continuing to do the work that you're doing, especially during these difficult times. Take good care of yourselves, your families, and each other.